Good afternoon, and thank you for joining us for the Cole Schotz COVID-19 webinar. My name is Jennifer Horowitz, and I'm the co-chair of the Corporate Finance and Business Transactions Department at Cole Schotz. I'm also a member of our task force to address legal matters related to the impact of the coronavirus. I will be presenting today with Randy Kochman, Steve Sarasky, and Gary Albrecht. We will be addressing the CARES Act and related relief. Randy will then address employment matters. Steve will address the tax relief, and Gary will address certain real estate matters. We certainly understand that many of you and your family and friends and clients and customers are undergoing and experience tremendous amount of unprecedented challenges. We hope this will provide you with helpful guidance in these uncharted times. We do appreciate that many of you have reached out to us in advance of this webinar, and we've been in touch with our clients directly on how we can help them, not only with the act and interpreting these most recent laws, but also how this impacts each of your businesses directly. We know that many of you have submitted questions in advance of this webinar, and we encourage you to do so during this presentation. We're going to try to address as many of them as we can in our limited time together. But to the extent that you have questions that are not addressed, please do contact each one of us or one of us directly, and we will try to do our best to answer your question. Certainly, many of these laws are changing. There are continued confusion, particularly with the Paycheck Protection Program, which launched today. But we are going to summarize the law as it stands at this moment without all of the potential questions answered. We understand. As of late last night, there was a further interim final rule, so we will incorporate that into our discussion. But just for a little background, I know many of you have different levels of familiarity with the program, so we'll give you some detail and I'll address some of the questions as they're coming through as I describe it. So the Paycheck Protection Program that was launched today authorizes $349 billion in forgivable loans to small businesses to pay their employee and other limited costs during this crisis. The banks directly are accepting applications for this. We understand some banks have already been accepting successfully applications, some are not. Some are using the applications that the SBA has provided, and some have tweaked them quite a bit. This is the program that had been authorized by the CARES Act last Friday, and we've been receiving Treasury alerts and fact sheets from the SBA with a variety of interpretations and in some cases modifications to what was in the CARES Act. Most of the CARES Act detail was ranges, so I'll go through that as we describe it, but some of it was a little bit more specific, and some of those rules have changed, so to speak, with these interpretations. The eligibility for the Paycheck Protection Program is that the company has 500 or less employees. Alternatively, if it exceeds that, it still could potentially satisfy the eligibility requirements based on their North American Industry Code, in particular for accommodation or hospitality and food service. In particular, when there's an evaluation of the headcount analysis for purposes of whether any company is eligible, if they do have 500 or less employees, to utilize the Paycheck Protection Program, the affiliation rules of the SBA do apply. So we have received a lot of questions on this, and effectively, if there are 5 different companies with common ownership and common control, and they are affiliates, those, for purposes only of the head count and determining that in fact there's 500 or less employees, would be aggregated. It doesn't mean that they file together, but it does mean that if they exceed 500 employees, they would not be eligible. I would pay close attention if you are submitting an application to the absolute requirements and instructions on that application. They are supposed to be uniform, but we have seen multiple different versions of it. One certification that is on everyone and required is that the current economic conditions resulting from the coronavirus crisis make the loan necessary to support ongoing operations. There is not a requirement that the borrower have no inability to receive the credit elsewhere, but they do need to be very comfortable that they can make that representation. In terms of the amount available under this loan, it is 2.5 times payroll costs. There have been a lot of questions related to how we calculate this, what period are we using. The payroll costs, of course, are the salary and the employee benefits and the state and local taxes, leave, retirement funds. And so companies are directed to have a monthly average payroll cost, and they are entitled to 2.5 times that amount in their loan available under the Paycheck Protection Program. That amount is capped at $10 million. There are some specific periods, and some applications have referred to using 2019 numbers. Some of the fact sheet from the Treasury contemplates more of a trailing 12-month number. Seasonal companies or new companies have different requirements, so it's important to pay attention to the details on each of them. One point that I've received a lot of questions on is the $100,000 cap for compensation for inclusion in the monthly payroll costs. Initially, there was some question that perhaps those that received compensation of $100,000 or more were not included at all. Current analysis on it is that you would consider and use the $100,000 compensation, but only to that point. So any excess is not included. And that would also apply to any employee that is less than $100,000, but together with their benefits. So there is some confusion and some discrepancy in terms of which way to go, but it is clear that any salary direct compensation in excess of $100,000 should not be included in the monthly. And whether for instance, a $90,000 individual with a salary of $90,000 or more would not exceed the benefits if it exceeds $100,000. So it's somewhat technical, and the rules have been very different both between the interim final rules released last night, the original CARES Act, as well as the fact sheet produced by the Treasury. The uses for the funds are to be used within 8 weeks of the effectiveness of the loan or the advance under the loan. They're to be used for payroll costs, interest on mortgage, rent, and utilities. Recently, although not included, I say recently, but recently time is difficult to keep track of these days, but within the past day, it's been clear that for forgiveness purposes, we will be the lender will be able to restrict how much is used for anything other than payroll. So while the use is permitted for interest on mortgage or rent or utilities, it likely will be capped at 25% of the aggregate loan amount seeking to be forgiven. In terms of other terms in this Paycheck Protection Program, any amount that's not forgiven will have interest at a rate of 1%. There were some questions on this because I know initially the CARES Act indicated it was a 4% interest rate. It then seemed as if it was a 0.5%. And now based on the latest last night, it's a 1% interest for any amount outstanding that has not been forgiven. The maturity is 2 years. That's fixed now and limited from the up to 10 years reflected in the CARES Act. The loan, any loan under the PPP program will be non-recourse to the owners, but that is only if it is used for a proper purpose. Of course, there are criminal penalties in addition to the possible non-recourse for any misrepresentations in connection with the application process or the submission of materials. This particular loan requires no guarantee, no fees. There have been some questions about using agents in this regard. It's a very unique circumstance. A lot of times in SBA lending scenarios, there are agents used. If there is an agent used, there should not be any fee to the borrower. There will be no collateral on this particular loan. And in terms of the loan amount, any amount that is not utilized in the 8-week period could be prepaid with no penalty. So to the extent, and we should all have these problems, we don't utilize all of the cash that becomes available pursuant to the program, we could, anyone could actually prepay any amount outstanding. The loan will be forgiven, as I mentioned, based on the amount of the funds used for the authorized purposes, subject to the cap at this time at 25%. Steve will address some of the tax impact of that. But if there is any outstanding indebtedness after the term of use, it will be deferred. So there will be no loan or of principal interest or there will be no fees for 6 months. To the extent that there's any amount outstanding, the interest will accrue from the date of the loan at that point and need to be paid. Particularly for this one, we've received a lot of questions, and I think part of it is because the banks are scrambling to get this program in place so quickly, but the borrowers are instructed to go directly to their lender at this time. We have recommended that if you have a business relationship with a bank that is an SBA lender, it would benefit you to go to that bank first. Some of them don't have availability, as we had mentioned, but there is some, there certainly is the ability to go elsewhere beyond the existing banking relationship. But the point is, for this particular loan, unlike the economic injury disaster loan, this is direct to lender. So on this, and I would apply for others, one question that's been asked that I want to focus on is covenant default. All borrowers are continued to focus on making sure they're in compliance with existing indebtedness. So while this is a great program, and I can't imagine any lender not welcoming the effective federal advance of cash that can be fully forgiven, you just want to be sure, because there hasn't been a prohibition by lenders in enforcing those types of covenants. To quickly move on to the economic injury disaster loan program, this is limited for small businesses based on their North American Industry Classification Code. So take a look at your revenues and various standards to be sure that you're able to and eligible to use it. It is only to be used in connection for this particular COVID-19 type of disaster loan that's been expanded by the CARES Act to directly address the disaster of losses and not just a downturn to the economy or other reasons. There does continue to be credit history requirements, but there isn't, again, there is not the requirement that there be credit available elsewhere. So there is no need to shop for these. And I should mention also for the Paycheck Protection Program, similarly, the terms are going to be fixed. There could be some differences in documentation, but no need to shop it because they're to be identical pursuant to the SBA's rules. Maximum on the EIDL is $2 million, and interest will be at 3.75% for up to 30 years. There will be no deferral and no forgiveness with that type of loan. That loan is direct to the SBA, so I encourage you to go there directly for that type of loan. For all of these loans, anything that is in violation of law by the federal or state governments will be restricted. They will not be able to be extended. It's our interpretation at this point that that would apply to the cannabis industry due to it not being federally compliant, even if it is within state law. A few things just to note: there's a number of other relief and loans at the state and federal level that you can consider. There's emergency loans. One point before I move on beyond the SBA loans is if you apply for the economic injury disaster loan, and there is the opportunity to receive an advance of $10,000 within 3 days of applying. That is the way the rule is drafted. We're hopeful that the SBA will be able to honor it in light of the high demand. And one point that I wanted to mention related to the demand is that we are encouraging those that are comfortable that they could make the certifications if they feel comfortable, that they can in fact submit their application as soon as they're able to do it. There has been talk about a phase 4 stimulus relief, which would potentially provide funds in excess of the amount allocated for this purpose. But the SBA and the Treasury have said at this point, these funds are available on a first come, first served basis. One really, one point that hasn't had as much of a highlight as I think it should is the existing SBA loan relief, that if you have an existing loan with the SBA, there is a 6-month relief. So that's something to take advantage of. It's intended to be automatic, but I would not hesitate to contact your lender and be sure that that's in the works, and if there's anything you need to do that. Lastly, there's a number of relief and aid that has been authorized under the CARES Act, and we've received a lot of questions about larger companies or companies that have private equity funds that may not be able to benefit from this program in its current state. These rules are changing frequently, as I mentioned. It is a fluid situation, so keep an eye out. We will continue to monitor ourselves. The mid-size loan program should be launched shortly. The Main Street lending program should be launched shortly, and those hopefully will provide more relief for each of you. With that, I think I'd like to turn it over to Randy to talk about some of the new rules and as it relates to employees.
Very helpful. Hopefully, I'm trying to unmute.
You're unmuted.
I'm unmute. You can hear me?
Yes.
Okay, great. Sorry about that, technology. Nice to see everybody. So for those of you out there, I'm Randy Kochman. I'm the chair of the Cole Schotz Employment Group. And in the pre-COVID world, I counsel employers on all types of employment issues. And here I am the last few weeks, focused mainly on COVID and trying to get everyone, employers of all sizes, through this trying period of time. The message that we're getting from the state and federal governments is that they're trying to help employees get through this with expanded unemployment and also encourage employers to keep employees on. So in my short time, my goal is to go over with you the Pandemic Unemployment Assistance Program, which is part of the CARES Act, and then also go over the Families First Coronavirus Act, and some related state laws, New Jersey and New York, and also answer some common questions that I've been getting again and again and again, because I'm sure some of you out there have the same questions. So that's a little ambitious. I'm just gonna jump right in and we'll see how we do. In the CARES Act, which Jennifer mentioned, there is the one aspect I'm gonna speak about is the unemployment. And some politicians have said it's unemployment on steroids. It is a huge expansion of the unemployment program. It was passed last Friday. It's effective 2 days ago, Wednesday, and it basically provides for expanded unemployment benefits. Typically, unemployment is up to 26 weeks. It is now up to 39 weeks if you find yourself unemployed for a COVID-related reason. It also provides for expanded benefit amounts. So in addition to what you get through the state, your state benefit, as we say, the federal government is funding $600 per person per week to those states who have entered into agreements with the government. Saturday, New Jersey entered into an agreement. So that $600 is in addition to the state benefit, and it will be available through July 31st. In addition, the Pandemic Unemployment, we'll say PUA program, also expands who is entitled to unemployment. So it used to be independent contractors, self-proprietors, new employees were not entitled to unemployment. Now they are. You have to, it expands almost anyone who finds themselves out of work is going to be entitled to something. And also, in my limited time, it's very hard to address each situation, who's entitled to what. But what I want to tell you is that any worker out there who finds themselves unemployed or unable to work or sick or has a family member who's sick, that employee is entitled to some type of benefit. Sometimes figuring out what the benefit is, or it could be a combination of benefits, is a challenge. Both the New Jersey Department of Labor and the New York Department of Labor have tried to put out helpful matrices. You can find them on their websites. but sometimes it's not that easy. But my message is that there is a benefit out there for everyone, and it's just maybe figuring out what it is that's going to be the challenge. So back to unemployment. In addition, partial unemployment benefits are available, so it expands how many hours you have to work to get benefits. It makes clear that furloughed employees get benefits, and I'll explain in a minute what that is. And it gives money, it infuses money to, again, those states that have entered into agreements. It infuses money to support this. In New Jersey, it's called Workshare New Jersey, basically the partial unemployment program. Partial if you're working, less hours than you used to work. One other thing it does is for those states that enter into agreements, that the federal government will send money to the states so that they can waive that first week of waiting. Usually there's a week where you don't get benefits while you're waiting. That's going to be waived in those particular states. So that's a very high level overview of unemployment. One thing that the Commissioner of Labor, I heard speak the other day, spoke to, he did want to caution everybody that, although the benefits claims are astronomical, they still have the same number of claimants. They still have the same number of agents processing these claims, and these people are overwhelmed. They did just sign the agreement with the feds on Saturday, so they haven't totally gotten guidance. So we know that some websites are crashing. His advice was just to keep trying and patience. So that's unemployment. The next thing I want to cover is the FFCRA. This is the Families First Coronavirus Response Act. This was passed first back on March 18th. It's effective from April 1 through December 31. It's a temporary law, and it does two main things that I'm going to go over. I cannot possibly cover all the things that this law does, so I want to remind you that there is a lot of information out there on the U.S. Department of Labor website, dol.gov. If you just Google Families First or FFCRA, FAQ, they're up to 59 or over 60 frequently asked questions. They've done a very good job, I think. They've amended them twice. And so a lot of commonly asked questions about the FFCRA will be answered there. Who's entitled? What do you get? For how long? Exemptions. I'm going to touch on a few, but I want to direct you to that resource. 2 days ago, the government also rolled out 124 pages of regulations. Those are not as user-friendly. We're blogging as much as we can on this, but I do want to just tell you that there's a lot of information out there. So basically, what is the FFCRA? It does two main things. It provides on a federal level for emergency paid sick leave, I'll say EPSL, and then it also expands the Family and Medical Leave Act. We call that FMLA+. Those are the two main things it does. So for the first 2 weeks, up to 80 hours capped, a worker, an employee who's been with an employer at least 30 days, so that's a relaxed eligibility requirement, can get up to 80 hours of paid sick leave for any COVID-related reason. So that means if you are homesick, if you have COVID, if you have symptoms, if you've been advised to self-quarantine, if you're caring for yourself in any way, or if you have a family member who is sick or has been advised to self-quarantine, or if you are home, any parent out there, because the schools are all closed. Those are all qualifying reasons. So what does it mean? It means you get 80 hours of paid sick leave paid by the employer, and then the FMLA plus component is another 10 weeks paid at 2/3. And the first 2 weeks are paid at different rates depending on the reason. So if you're home for yourself, you get more money, $511 a day with a cap, than if you're home caring for someone else, that's around $200 a day. So it depends on your reason what you're going to get, but the employer has to pay this. So all the employers out there are not thrilled about that, or not that they're not thrilled, it's a little scary to tell employers that they have to pay basically any parent, which is a lot of us, for up to 12 weeks. The government's response to that is the tax credits. And I don't talk about tax too much, that's for Steve and Jennifer, But I will just point out that the answer is they're trying to encourage employers to provide these benefits, and what the employer gets in return is tax credits. They've put out guidance on the tax credits as well, how you get those. You don't actually have to pay these employees and then submit. You could just withhold, well, you do pay the employees, but you don't have to pay the tax. You keep the portion of the tax, the quarterly payroll tax, that you would have submitted for those employees who are on leave. And then if that amount is exceeded, if the amount you pay employees exceeds that amount that you're withholding, you can fill out a form 7200, and there's guidance out there on how to do that. So that's the highlight of my tax presentation. Then when we talk about the Expanded Family and Medical Leave Act, that 10 weeks is for child care only, and it's for 2/3, you pay the employee 2/3 of what they would be making for the extra 10 weeks. Okay. There are a couple of highlights to this FFCRA. There is a small business exemption, which we just got guidance on. So typically the FFCRA applies if you have 500 or less employees. If you are a small business with 50 or less employees, and this is going to be a burden on you, there's a possible exemption where you can apply to the government and say, I can't do this, I can't pay this. And there are guidelines out there that were just put out. They're on the FAQs and the regulations, and we're blogging about it today, about what you have to show. So I just want to highlight that that's a possibility for all you small employers. The other thing I want to highlight for you healthcare providers out there, there's a healthcare provider exemption. Of course, this is a defined term. We just got guidance on this as well. But certain healthcare providers can claim that they are exempt from this program too, and they don't have to provide the 12 weeks of leave to their employees. A couple other things before I pass the baton. A few commonly asked questions that I'm getting I picked the top 3 questions. One, the poster. FFCRA, we blogged about this too, requires that you post this notice of employee rights. Well, for a lot of people who are working remotely, teleworking, no one's in the office, how do you post? The guidelines make clear you can either email to all of your staff, or you could put on an intranet or extranet or whatever you want. So that's the posting. Even if you think you're a small business employer who's exempt, still put up the poster. The second biggest question I'm getting is, we call it the fearful question. For those businesses out there who are still operating and struggling maybe because people don't want to come to work because they're fearful, and every week that goes by I'm hearing gets a little more challenging because there's news that's very anxiety producing. How are you going to run your business if your employees don't come to work? Maybe they're not sick, they don't qualify for the sick leave, they don't have a family member that's sick, but they're just fearful. Well, it's a tough question. It's not a one-size-fits-all answer. I can tell you there's guidance in New Jersey and New York, and the commissioner has said, generally speaking, that is not an unemployment qualifying event. But there may be other benefits available, and it may depend on who is the worker. Do they have a pre-existing condition? How old are they? So it's a fact-by-fact basis. It's certainly a real challenge for industries who are still trying to operate. And I would also say it may depend on the type of industry that you're in, how many employees are calling out, can you still run, things like that. So you have to look at that. But I would point you toward those matrices, because both the New York DOL and the New Jersey DOL address this on their websites. And the last question I have is that I'm getting a lot, and I just want to clarify, is for those employers who are not continuing to operate and are struggling and dealing with terminations or layoffs, what is the difference between a furlough and a layoff? And a furlough has become a commonly used name in all of our households these days. And before COVID, it was really limited to seasonal industries. You would furlough employees in the winter maybe, and then they'd come back on. Technically, it is not a legal term, but technically what a furlough is that you're laying off employees with the expectation and intention that they will come back. they're usually not taken off your books, although they're not being paid, and usually they stay on benefits at least for some time. But that's not, it depends. Every situation is different. You can have different furloughs in different companies, look different. And benefits, I will point out, if you're considering layoffs or furloughs, one thing we want to keep in mind is how benefits are impacted. Either way, you're not paying employees. Either way, they get unemployment. State doesn't care. But how do benefits work? And I will just say that a lot of the carriers are relaxing their normal requirement that someone be actively at work to stay on benefits. In this time, I know some of the carriers have said through May 31, they will allow you, the employer, to keep your employees on benefits, even if they're not working, so that they can continue to collect benefits. So you want to be checking with your carrier on that. So that's pretty much what I wanted to cover, and hope everyone is well. And I'm going to hand it over to Steve, who's going to talk about some tax issues. Thank you.
Actually, before we swing it over to Steve, one thing that I wanted to mention that relates to your question of terminations and furloughs, and it really does impact the ability to have full forgiveness on the loan, is what employers do following the time or even prior to the time they receive the funds. So the concept of the forgiveness is that the 2.5 times payroll costs that you actually receive in the grant, in the Paycheck Protection Program, technically not a grant, but a loan, should be fully forgiven if you use it. That ability to be fully forgiven is limited to the extent that there are layoffs or reductions in salary of more than 25%. In the event that people have already terminated people and they bring them back before June 30th, then there could be still the opportunity for full forgiveness. So there's been a lot of questions with your discussion, Randy, on furlough and termination and how it relates to the forgiveness. And you can still, regardless of what's been done to date, cure that with full forgiveness and have the loan be forgiven if the employees are brought back on. Doesn't need to be the same people, because some people have said, you know, what if somebody decides they don't want to come back on? If you maintain the head count and you maintain 75% of the payroll costs, then there should not be reduction. Other question, quickly before I turn it back over to Steve, is yes, you can get the economic impact disaster relief, economic injury disaster relief loan at the same time as the PPP. They just can't be used for the same costs. And that's some of the analysis, even between deciding with the tax credits versus the taking advantage of this loan, which Steve, maybe you can address that and your other matters.
Great, I'd be happy to. Good afternoon, everybody. I'm Steve Sharaysky. I am in the tax, trust and estates practice at Cole Schotz, which is a terrific group within the firm. I have been in that group for many years, and my practice is largely focused on tax and sophisticated estate planning. There is a lot of recent developments. There is a lot in the CARES Act, so I'll focus my comments on the tax aspects of it. Thanks for joining us on Friday afternoon. For anybody who is finding the days run together, today's Friday. You know, I hope everyone on the call is safe and their families are safe. I'd like to have a shout out to our healthcare workers who are having a very different experience than those of us at home right now, and we're grateful to them. And I think we're all hopeful the economy gets moving again as soon as possible. A couple of general comments on the stimulus bill. One, you know, that you've got 4 lawyers on the call explaining a lot of detail about it and other changes. It's fairly complicated. Having seen tax legislation over the years, it is usually my wish that things were more simple. But there's a lot of ins and outs to the new law. It's been in force for a week. On the loan programs, which are really the most of appeal, you know, of appeal right now and most immediate concern, there's been a lot of questions and the SBA came out with these regulations last night. So it is a moving target. Every day is a little bit different. And yeah, we are trying to be patient. The other is I think of it, we've been calling it a stimulus bill for a week. I think it's probably more accurate to call it a disaster relief bill at this point. As you digest what it says, it really is more trying to keep things on a status quo or keep money moving in the economy for, around 2 months. And in that sense, to not have the domino effect of failing banks and failing businesses. And I think they're trying to just get through this disaster period is really what it looks like to me. So I share that comment with you. As far as the tax provisions in the bill, there are a couple of big ideas that affect everybody that I want to mention. There are some smaller, still broadly applicable, but smaller points where the government has given some concessions, and we'll point out those. And then I've got a couple of points on estate planning aspects of this current situation at the end. The big concepts in the bill, and again, most people we have seen are focused on these loans, the paycheck protection loans in particular. So the tax provisions are a little bit secondary, but there is a payroll tax deferral in the CARES Act. And what they have said is that employers and self-employed individuals can defer the employer portion of the Social Security tax withholding. That is the 6.2% portion of the employer's share. You still have to pay the 1.45% Medicare portion, but you can defer the Social Security portion on the employer side. That deferral lasts until 2021. You repay half of the amount deferred then, and that the other half is repaid at the end of 2022. As an example of that, if you have $1 million payroll from the end of March to the end of this year, and you can defer the 6.2%, that's $62,000 that you can defer, and you'd pay back half at the end of 2021 and half at the end of 2022. The second big piece in the tax provisions of the bill is they call it the employee retention credit, which is really a payroll tax credit. They call it a refundable credit, which means you get it as long as you qualify, and it's not hard to qualify. And it basically equates to a $5,000 per employee credit if your employees receive over $10,000 in wages. For companies with less than 100 employees, all of your employees count in that calculation. If you have greater than 100 employees, only employees who were furloughed or had reduced hours would count. But the idea is you figure out your qualifying employees, you will get a credit of $5,000 per employee. And again, it's a way to keep money in employers' pockets is what they're trying to do there. It's an important point that if you qualify for the loan forgiveness under the Paycheck Protection Loan, then you don't qualify for the payroll tax deferral or the employee retention credit. So that's a bit of an either or choice. If you get the loan, in our quick calculations, the Paycheck Protection Loan at 2.5 times your monthly payroll, which can be forgiven if you qualify, et cetera. It seems like it puts more dollars in most employers' pockets, but of course it's going to vary case by case, and you need to look at your own facts and circumstances. The third point that I want to touch on, which just goes back to what Jennifer was talking about with the payroll protection loan, and what is 2.5 times monthly payroll. A common question we're seeing is about K-1 employees, or to be precise, if owners get paid as guaranteed payments, or they get paid through distributions, often in an LLC or an entity treated as a partnership. How is that treated? And there isn't guidance on that. So that's an unknown at this point, although we've had a number of discussions on that issue. The logic of it to us is that guaranteed payments, which are treated as compensation, would be treated as payroll and should, again, we don't know, but should be treated in the calculation of what your monthly payroll is, whereas distributions of profit from a company, which are not compensation, likely pass out to the owners. The owners may be treated as self-employed for that portion of their K-1 income, and they may have their own ability to qualify for a loan as a self-employed individual. So that's a common question we've seen. On some of the specific areas where there's tax benefit in the CARES Act, I'll make a few points about them. One is that if that loan is forgiven, it does not count as income. So there is a concept in the tax code of cancellation of indebtedness income, or COD income. When the bill specifically provides that when the loan is forgiven, it's not taxable income. Employers, you don't have to pay tax on the forgiven amount of the loan. There are a couple of provisions in the bill that are very helpful for real estate people. One is in the prior tax legislation, the Tax Cuts and Jobs Act, they limited interest deductions, business interest, to 30% of adjusted taxable income. And for many real estate people who have loans, that limit is a real limit. In the CARES Act, that limit is expanded to 50% of adjusted taxable income for tax years 2019 and 2020. So that's a give to the real estate industry. For partnerships that have already filed 2019 returns, the IRS said yesterday on a call that they will have a procedure for amending partnership returns. So if that's an issue for anyone on the call, you should be able to amend 2019 if you filed already. The bill corrects a drafting error from the Tax Cuts and Jobs Act that was called the retail glitch, which didn't allow usually retailers or restaurant owners to deduct interior improvements immediately. And they had to deduct those over a longer period of time, or depreciate those costs over a longer period of time. So this glitch was corrected in the legislation that passed last week. For restaurant owners, retail stores, people doing interior improvements, you can now deduct those costs in the provisions on bonus depreciation. They can be deducted immediately. In the charitable area, 2 points. There is a $300 above the line charitable deduction for individuals who don't itemize. So pretty much all taxpayers in America will get an additional $300 charitable deduction they give to charity. And also, there is an AGI limitation. Usually you can deduct charitable gifts up to 50% of your adjusted gross income. That's removed for this period. So for 2020, you can deduct up to 100% of your charitable contributions for cash contributions and contributions not to a donor advised fund. So for people who run into that limit, who give a lot to charity and have AGI limits, that's a big give, and it will encourage charitable giving in 2020. In the qualified plan area, they really waived all the penalties and for drawing money out of your IRA or your qualified plan. So for people who qualify, who either have coronavirus, have a spouse who has it, or are unable to work because of it, if you withdraw funds from your qualified plan, the 10% early withdrawal penalty is waived. If you borrow money from your qualified plan, you don't have to pay it back for 3 years. The usual time period is 60 days on that loan. And also for people who have money and are in the period where they're taking RMDs, required minimum distributions, you don't have to take an RMD in 2020, and you don't have to pay tax on it. So for people who don't need to take their RMDs, you could defer the payment and not take it in 2020. There's a couple of quick points on ways employers who wish to can give money to employees in a tax-free manner. The bill allows student loan repayments to employees, so an employer can pay up to $5,250 to employees who have student loan payments, and that will be done, and that's tax-free income to the employee and deductible by the employer. There's also a provision in the code on qualified disaster relief payments that allows an employer to reimburse an employee for their payments or expenses they had related to a disaster like the pandemic we are experiencing. So that doesn't apply to wages, but if as an employer you reimburse employees for medical expenses, childcare, utilities, other expenses, that can be a deduction for the employer and tax-free income to the employee. I'm going to make two final quick points on estate planning, what we are seeing in common questions. So for people who don't have their estate planning up to date, we have seen a good bit of this with New York doctors and healthcare professionals. You should update your documents. We are a little challenged in getting documents signed, but we're getting it done. And it is really important to have up-to-date estate planning documents, and we are doing them quickly for a number of people who have that concern. The other is in the area of advanced estate planning, where values right now are quite depressed and very different than what they were a few short months ago. We currently have an $11.5 million person exemption per person from estate taxes. If you have a taxable estate and are considering estate tax planning to reduce your estate tax, this is a time to really think about estate planning techniques that move assets out of your estate, often with a discount or a discount in value, because values are so low today. And we are commonly in discussions with clients in that situation who are reacting to this current situation. It's hard to call it a great opportunity, but in that respect, it is a great opportunity. With that, and running short on time, I will turn it over to Gary Albrecht, who's, I think, going to address very important questions that landlords and tenants and others are having in the real estate context. Thank you.
Thanks, Steve. This is Gary Albrecht. I'm a co-chair of the real estate department at Cole Schotz. Just a housekeeping note, if you hear screaming children, barking dogs, they're at Steve's house, not mine, so don't blame me on that. The CARES Act is really a tremendous opportunity for real estate owners and operators who are eligible, for these programs that my colleagues have discussed. But some of the wants from the industry, like direct loan relief or directed assistance to, let's say, retail, is not in there. Indirectly, it's there, but some of the lobbying that went into it had certain desires that may not have been addressed by the act. But the tax issues that Steve addressed are really important for the real estate industry. And just speaking of taxes, one thing I wanted to note for those in New Jersey, that New Jersey tax appeals have been pushed from April 1, which is the normal deadline, to May 1, or 30 days after the date of emergency declared by the governor has ended. It's a later of. So just something to keep in mind. I'd like to talk kind of practically just about what I'm seeing in the market, because I have been practicing for over 25 years and I've never before seen such a gulf between what real estate documents say on an issue and then the business decisions that are made or being contemplated in response to the issue. And what I mean by that is, under loan documents, leases, borrowers have to pay in full and on time. But given the reality that with businesses closed, they're severely limited, moratoriums on collections and evictions, and courts essentially being closed for business for these kind of contractual matters, many borrowers and tenants won't pay in full and on time. But unlike pre-COVID-19, this doesn't mean that lenders will move to foreclose or landlords will move to evict in the near term. Now, in addition to these these non-payment defaults under documents, there are also secondary defaults being triggered, such as under loan documents. You have covenants, representations, warranties regarding cash flow and other financial covenants, and material adverse change provisions are being triggered, which is basically a way for a lender to say that things have changed since since the loan was made in an adverse way, and that may trigger things like escrows. It could trigger even up to default. In retail leasing, there may be prohibitions on closing for business and addressing operational issues which just can't be met. And for purchasers, we're seeing lenders sometimes backing out of deals or changing the terms after the contingencies have expired. So I've seen many purchase and sale agreements terminated in a due diligence period because of the current uncertainties in the market, including with lenders. So you have people taking a wait and see approach. So we have a lot of parties that we talk to and just, around the country that are looking for exit strategies or relief from payment obligations. And, some of the common ones that I'll touch on is one is force majeure, which basically is a concept that excuses delays of performance or obligations for a casualty, other acts of God. Sometimes it extends to events outside of parties' control. And in most sophisticated commercial leases, that clause is there. However, it generally doesn't delay or forgive the obligation to pay rent. And just to note that many leases provide that the party seeking to invoke the force majeure clause has to do so within a certain period of time following the event, otherwise the ability to claim it is waived. So if you do think under any document that force majeure protection exists, you want to make sure that those notices are timely sent. Loan agreements and mortgages either don't have force majeure type provisions or they're very limited. In retail leases, there may be rights such as an ability to pay reduced rent or to terminate the lease if sales fall below a certain stipulated level. We call that a sales kickout. Or if minimum occupancy levels aren't sustained, we refer that as co-tenancy. So if you are a tenant under that type of lease, you can see if those provisions are in there. We have businesses looking to business interruption insurance. And while I would say that if you think there's a chance that you can collect, I would put in a claim, but we're running into a virus exclusion in most policies, and also the position of insurers that this isn't a direct physical loss, this pandemic. So I'm sure we'll see a lot of litigation on this, but so far that hasn't been sort of the cure-all that would be nice if it were out there. So the realities that we're facing now are lenders, landlords have documents in their favor, and other legal theories that borrowers and tenants have been exploring, such as forgiveness due to legal doctrines like impossibility of performance or frustration of purpose. Those are fairly hard to win, and courts aren't open right now to adjudicate those claims. But the reality is that many borrowers and tenants have been proactive and have asked for mortgage or rent relief. And lenders and landlords, they've generally been taking a wait and see approach because March payments were in, and there was a lot of uncertainty about federal and state relief, whether it would come and what it would look like. So we are getting some more clarity now, and discussions have already commenced between parties, and they're certainly going to accelerate. And in my experience, most of the talks about any kind of a settlement, so to speak, is about deferral of rent or loan amounts as opposed to a forgiveness. I've also seen, the ask and sometimes the agreement to forgive certain payments, but then to extend the term of the obligation. So what lenders and landlords are looking for when they receive these requests are that losses be substantiated. Maybe not if they were forced to close altogether, but certainly if they were allowed to stay open, even if it was on a limited basis. They're also going to want to know that the borrower or the tenant sought all relief available under the CARES Act or any state program that would provide relief. And usually you're going to see lenders and landlords looking for what we call clawbacks, which essentially means that if there's a default under the agreement, this new agreement that's been reached, the concession, that all of the amounts that were deferred, or let's say if they were forgiven, would become due. So, and Steve kind of touches on this in the estate planning context, but it's been very challenging to get new deals done, even when we can, get the parties to the table, because many jurisdictions, recording offices are closed, or they're working with a very small staff. So jurisdictions are, trying to help by allowing things such as remote notaries. Title insurance companies are generally continuing to issue title policies to facilitate purchases, sales, and financings, but they are requiring additional documentation and protection for themselves, including what we call a COVID-19 affidavit and an indemnity. With all of these recording offices closed or way behind, there's a concern that something could have arisen between the last search, the last time the title company was able to look at the state of title of a property, and when the mortgage or the new deed is recorded. So generally, sellers have to indemnify the title company for any of these intervening encumbrances or liens, especially if it was caused by them. Now, there may be a cap on the insurance amount. That's sort of a moving target. So certainly if it's a larger transaction, we're obviously checking with title insurance companies to make sure that that is something that that's not going to prevent or inhibit the deal. But we are getting deals done, and although it's a challenge, it's still possible. So with that, and 3 o'clock on the dot, and no screaming kids, barking dogs, I'll say goodbye. I hope everybody stays well and is safe.
Thanks, Gary. So before we sign off, just to reference you to our resource center, which is on our Cole Schotz page, if it can be helpful to you. Of course, you're welcome to reach out to any one of us or your principal contact at the firm. We're happy to help. We've been doing this with, many of our clients, unfortunately, as they struggle through this period. And we wish you all good health and well-being during this very challenging time. All the best.